Hello, and welcome to Ipsa Dixit, a podcast on legal scholarship. I'm your host, Brian L. Fry, Spears Gilbert Associate Professor of Law at the University of Kentucky College of Law. My guest is Jonah Gelbach, Professor of Law at Berkeley Law at University of California. We will discuss his draft article, Estimation Evidence, which will be published in the University of Pennsylvania Law Review. So welcome to the show, Jonah.
Thanks very much, Brian. Delighted to be here.
Yeah, look, I'm glad to have you on. This is like a fascinating paper because it kind of sits at the intersection of civil procedure and evidence law, and kind of illustrates how intertwined the two disciplines really are. And I really enjoyed reading it, but I will admit it was a little even more technical than some of the papers I usually talk about on this show. So I want to kind of walk through some of the core ideas so that listeners have a kind of a baseline for understanding the really, I think, subtle and important point that you're making here. So in the paper, you focus on how courts should use statistical estimation evidence when deciding motions for a judgment as a matter of law under the federal rules of civil procedure. So I was wondering if you could start by explaining what exactly is statistical estimation evidence.
Sure. So I'll note as well, and I imagine we'll get there, but that the paper also discusses quite a bit the issues that surround admissibility in court of expert testimony about such evidence. The standards and the issues are a bit different. I guess I should say the analysis is a bit different in the two places, but the result turns out to be pretty similar. So having said that, what do I mean by statistical estimation evidence? What I don't mean is the kind of statistical evidence, quote unquote, that people have traditionally meant in the evidence law literature when they've talked about problems like the blue bus problem or the gate crasher problem. In those problems, it's basically taken as given that the probability numbers used are, for lack of a better word, true or accurate. So in the blue bus problem, it's assumed that 80% or 90% or whatever telling one uses of the buses in town are blue, and the rest are red. And what's at issue is, are we going to allow nothing but that fact to be the basis for a determination that the blue bus company was the one that's liable for a bus accident when there's testimony that the bus in question was blue and no other evidence? That's the kind of conventional use of the term statistical evidence in the evidence law literature. I don't mean that. What I mean is quantitative estimates, which may be estimates of probabilities or estimates of some other object of interest. So, for example, in antitrust law, you would care about the impact on prices. That's probably not a probability estimate. But some sort of quantitative estimate in which hypothesis testing is likely to be used in one way or another, statistical hypothesis testing is likely to be used to quantify the strength of the estimates in question, which is to say, to determine whether they should be treated as if they're, there's sufficient evidence of the phenomenon in question that they come into evidence in court, and or a reasonable jury or fact finder could find for the proponent of such evidence on the merits.
Okay, so I think it would be helpful to sort of use an example to illustrate. And if I recall correctly, in the paper, you use the example of I think it was Lipitor litigation, and evidence about the likelihood that it caused diabetes. So maybe you could describe that particular statistical estimation evidence, sort of how that worked, and sort of like the different ways that we might think about evaluating the evidence with respect to its reliability.
Sure. So that case involved an MDL, a multi-district litigation, in which the maker of Lipitor was sued by thousands of people, most or all of whom I believe were women, alleging that taking Lipitor as instructed by their doctors and, as recommended by the manufacturer, led to the onset of type 2 diabetes. These cases were consolidated. You can't bring them as a class action due to other line of case law we're not going to get into today. And so they were brought in, sort of consolidated as a multi-district litigation in federal court in South Carolina. And a really important question in the consolidated pretrial proceedings turned out to be whether the plaintiffs, and here I mean plural, the expert that the plaintiffs' steering committee had presented on the issue of causation, general causation. In other words, does Lipitor ever cause type 2 diabetes? This expert testified that about a randomized controlled trial study that showed that 3% of the folks who had taken Lipitor ultimately, or at least within the time period of the study, had experienced type 2 diabetes incidents. In other words, they didn't have it at the beginning of the study, and then they did. They were diagnosed with type 2 diabetes by some point before the end of the study. By comparison, 2.6% of those who received the placebo in the randomized trial, right, they were the control group in the Lipitor study, developed type 2 diabetes. So the difference in incidence was 0.4 percentage points. In other words, 3% minus 2.6%. The expert, I should be clear, this is at a particular dosage, namely 10 milligrams, which is a low dose in context. And so the question that the district court and then ultimately the Fourth Circuit Court of Appeals addressed was whether the expert in question could be allowed to testify that there was a 10 milligram, that there was a causal effect of Lipitor taken at the 10 milligram dosage on the basis of the evidence I just described. It was a relatively large randomized trial, so even though the difference, 3% compared to 2.6%, sounds like it might be kind of small in substantive terms, it's about a 15% increase for those who took Lipitor compared to those who were assigned not to. It's a sufficiently large study that one might think that was a real effect. And then so that's the quantitative estimate at issue. That's what I would call statistical estimation evidence. And then the issues that arise that my paper is, the issues at which my paper are directed are the ones related to, well, should we allow this expert to testify that this evidence is sufficient to conclude that there really was a causal effect of Lipitor on type 2 diabetes?
Okay. So in the context in which the court had to decide whether or not to admit that particular expert testimony, what's the abstract legal standard? In other words, what question is the court supposed to be asking in that context? Okay,
so let's unpack that just a little bit. If we imagine for a moment that the evidence had been admitted at trial, then, or were admissible anyway, had been determined to be admissible for trial, then there's no question that the standard for the fact finder at trial, whether through jury trial or bench trial, would be the preponderance standard. The question of whether the testimony should be admissible, if it didn't involve expert testimony, would be controlled by a couple of different federal rules of evidence. One is Rule 401. That's the lowest bar here, which just says that the evidence has to show that a fact of consequence in the litigation is more probable or less probable as a result of knowing the evidence. In other words, you'd change your mind in one direction or the other if you knew the evidence compared to what you would think without knowing the evidence. It's an incredibly low bar. Everybody understands that to be an incredibly low bar. There are a bunch of other evidentiary rules out there. The most important of them is outside the expert evidence context here would be Rule 403, which says, you can't allow even relevant evidence. Judges would be justified in excluding even relevant evidence if there were some risk of, or sufficiently high risk of, confusing the jury or leading to unfair prejudice against one of the parties, and a couple of other things. But those are the main ones for our purposes. What's really important in this context is the body of law that surrounds expert evidence and expert testimony, and that's encapsulated by Federal Rule of Evidence 702. It's often referred to as Gelbach, after one of the cases that really developed these issues. And there's such a thing as the Gelbach trilogy. There were 3 cases in a short period of time. The other 2 were Jonah and Kumho-Tyre. The 3 of those cases together, the law in those cases is essentially adopted in an amendment to Federal Rule of Evidence 702, so that the current rule that exists essentially embodies all of those considerations. So you ask the question, what's the standard for admissibility here? Well, the expert's testimony, it was Dr. Singh was the name of the expert in this case, would have to, first of all, be relevant under Rule 401. So it would have to be enough to change what a reasonable observer might think after seeing the evidence. It would have to be not too confusing or unfairly prejudicial to the other side. In this case, that would be the defendant. And then it would have to pass this Rule 702 standard. The main things there are that the expert himself be the sort of person with the sort of expertise who could provide information that's helpful to the jury by explaining things that are outside the scope of a lay person's understanding of these issues, and then also a slew of issues related to reliability of the objects of the expert's testimony, and the requirement that the expert considered all the evidence that should fairly be considered in forming his opinion, applied reliable methods to the reliable evidence, and that sort of thing. But it's, I think, useful to understand that the preponderance standard that comes up for that's at issue for whether the evidence would be sufficient once admitted to find for a party has to be in mind when we think about the admissibility standard under Rule 702 and the body of law related to experts. Because it can't be helpful to the jury to know a piece of evidence if that evidence wouldn't have any impact on the determination of the case, and vice versa.
Okay, so as I understand it, courts typically, in evaluating this kind of evidence, use like a statistical significance sort of approach, which is common within the various scientific fields that the evidence is being developed. And as I understand it, in your paper, you're arguing that in this context, that's actually not the right standard to use in evaluating the evidence for this particular use. So could you explain how that standard works, why you think it's the wrong standard, and what standard ought to be used instead, at least as a legal matter?
Sure. That's a lot right there. So let me try and take it in pieces, and please do let me know if I've neglected to attend to part of it. So the first point I want to make is that there's a lot of variation in what courts say they're actually doing when it comes to these kinds of questions with respect to statistical evidence and hypothesis testing. And largely, I think that's because there are many judges out there who are very, very smart people who work really hard, really want to understand these things, but they're just not trained in the issues. And so they don't necessarily grasp them, and they sometimes make conceptual errors in describing what conventional approaches to hypothesis testing, which you're right, I'm critical of the use of those conventional approaches in this paper, what those conventional approaches entail and what they actually tell us. So let me take a step back and describe what conventional hypothesis testing, by which I mean what's often called null hypothesis significance testing, entails, and then I'll get to the other parts. So for null hypothesis statistical significance testing, it's helpful to imagine for a moment that there are only 2 possible states of the world. One is let's stay with the Lipitor example. One is that Lipitor causes type 2 diabetes, and the other is that it doesn't. So if it doesn't cause type 2 diabetes, then and in fact, when we say it doesn't cause, we also mean it doesn't reduce the incidence. It's not beneficial to people who have taken Lipitor. It just has no impact in either direction. So if we start from that perspective, that zero impact is what's usually denoted the null hypothesis in these kinds of discussions. So null just mean, NULL, meaning nothing, no impact here. The null hypothesis, under the null hypothesis here, we know that any difference in the incidence of type 2 diabetes in the randomized controlled trial I talked about, which is known as the Ascot LLA trial, any observed difference is just the result of random variation. You get a sample of people, you give some of them Lipitor, or you give others a placebo, and it's random which people get which. Even if there's truly no causal effect of Lipitor on diabetes for anyone, sometimes by happenstance, there's going to be more people in one group or the other who get type 2 diabetes. That's just the nature of taking finite samples in the real world. Under the null hypothesis, the extent to which there should be a difference in the incidence of type 2 diabetes is going to be knowable in a large enough sample. There's something called the central limit theorem, which basically tells us that the difference in the proportion of people who are diagnosed with type 2 diabetes after receiving either Lipitor or the placebo is just very unlikely to be more than a certain amount, and that certain amount depends on the underlying incidence in the groups of type 2 diabetes in general, and so I can't quantify that without knowing some more about that. But null hypothesis significance testing works by saying, well, let's look at the actual difference that we observe in the data, and let's figure out whether that difference is more or less than a particular difference based on this probability distribution that I just told you we can determine. And so the structure of and if it is more than that, then we say, oh, that would be very surprising to observe if there truly were no impact of Lipitor on type 2 diabetes. So the structure of the idea is we say, well, if there were no impact of Lipitor on type 2 diabetes, how likely would it be to observe more than an X percentage point difference? And as long as anytime the likelihood of observing more than that difference isn't too great, we determine, well, there must not have been any difference. Okay, so what's important about that and problematic, I argue, and I'm hardly the first. I want to emphasize this. There's an old line of criticism of this approach to causation testing, both inside and outside the law. The problem is that you notice I never said anything in that discussion about the likelihood of observing the data if indeed there were some causal effect of Lipitor on type 2 diabetes. In other words, it might be really unlikely to observe what we actually see if there's no effect of Lipitor, but it might be even more unlikely to observe what we actually see if there was, a relatively small effect of Lipitor or some more moderate sized effect. The nature of legal proof is supposed to be comparing the plausibility or the likelihood or the probability. We can discuss or not discuss the technical differences between those to the extent that there are any, but it's supposed to be about comparing the probability of the plaintiff's story given the evidence to the probability of the defendant's story given the evidence. And what I've just described to you is an approach that starts by assuming, in this case, the defendant's story is right, and then asks, how unlikely would it be to observe the actual evidence? But then it never compares that to anything having to do with the story that the plaintiff would tell. So there's two ways in which it's problematic. One is it asks about the probability of the data given the hypothesis that there's an effect or not, rather than asking about the probability that one or the other hypothesis is right given the data. Okay. And then the second problem is that it just never even engages anything to do with the probability of observing the data if the plaintiff were right. So it isn't comparative in the way that the law is on its face supposed to be comparative. And it uses the wrong object anyway in doing the halfway analysis. So it's got these two problems. The alternative would be, or the most sort of natural alternative would be to use a method or a collection of methods known as Bayesian analysis. And there's such a thing as Bayesian hypothesis testing. And my paper presents a set of approaches that would allow us, or that do allow us, to compare the probability that one side or the other is right, given the data we actually observe. And if you think about it for a second, you realize that's what courts usually ask plaintiffs to prove in court. So in a case that has nothing to do with statistical evidence, let's say a garden variety, personal injury trial where somebody has slipped on the sidewalk, and the question is, did the defendant take enough care in shoveling the walk on time after a snowstorm happened? We would ask people on the jury to determine, given the evidence that you've heard at trial, do you think it's more likely that the defendant failed to take due care, or more likely that the defendant did take due care? And in just that sense, my argument is we ought to be asking people on the jury, if a case ever got that far, is it more likely, given the evidence, that Lipitor causes or doesn't cause diabetes? That's very different from the structure of what we ask if we use null hypothesis significance testing. The approach of null hypothesis significance testing, and I'll shut up and let you ask another question. The approach of null hypothesis statistical significance testing was just basically imported from scholarly use of statistics, particularly in the social sciences, into court. That's how it got there. It's not like anybody ever said, what's the best way to use statistical estimation evidence in court, and then wrongly wound up with this. It's just what scholars often do in what's known as the frequentist paradigm of hypothesis testing. It's controversial among scholars whether that approach or the Bayesian approach is the better one. But on the face of it, what we say we're supposed to be doing in court clearly supports the Bayesian approach rather than the frequentist one.
Yeah. So that was a lot. But if I understand that in your paper correctly, essentially the observation is that the standard approach that courts have been using is putting way too high a burden on the introduction of the evidence. Like, it's almost like saying you don't just have to show some likelihood that this took place, but you have to prove it took place before you can introduce the evidence in the first place. And that's way too high of a standard, and that the kind of evidence you're talking about here, the kind of statistical evidence you're talking about, is actually particularly well suited to this Bayesian weighting of probabilities approaches. Is that right?
Yeah, I think all of that was relatively well said. I'd offer an amendment to it, which is, I would say, whether we say that courts have been holding plaintiffs to too high a standard, usually it's plaintiffs, it could be defendants, but people presenting statistical evidence in order to establish causation or other related proposition, whether we say it's too high a standard is a question that can be answered only by reference to a choice of evidentiary threshold. In other words, a standard of proof or a standard of evidence. And it might well be that we should demand that plaintiffs meet a very high standard, because otherwise we'll get too many lawsuits, or we'll do something unjust by transferring too many resources from potential defendants to potential plaintiffs. There might be all kinds of other economic reasons to worry about those things. I have absolutely no problem with any of those claims, at least for purposes of this paper. I'm not sure they're right, but they could be. My argument is rather that if we say we're applying the preponderance standard, then we're necessarily holding parties to a much stronger evidentiary standard than what we say the law actually entails. There's a whole other part of the paper that's about the considerations that are at issue when
courts, particularly federal courts, rather than legislatures, are the ones making those sorts of determinations. But those are fundamentally normative determinations about the relative, the relative burdens we want to place on folks who are likely to be plaintiffs versus defendants. They're separate from the underlying, or I should say the sort of the overlying question of how we should use statistics once we have determined what the standard is.
Mm-hmm, mm-hmm. So you used in the paper this concept of the plaintiff's most favorable juror to identify or to explain why the alternative standard you're describing is consistent with sort of the preponderance standard we say that we're using, and the alternative standard is not, and why if we assume that plaintiff's most favorable juror sort of argument, it shows that the evidence would always be admissible when it satisfies the standard you're talking about. Why is that?
Great question. So 2 points to focus on here with respect to this plaintiff's most favorable juror concept. The first is that in this paper, I don't purport to be providing advice to a fact finder at the merits stage. In other words, I'm not trying to tell a juror how to answer the question who should win on the issue to which statistical evidence can speak. I'm not telling a judge, hey, if it's a bench trial, here's how you should choose for whom to find. What's important here is to recognize that at key procedural moments, namely motion for judgment as a matter of law, which happens at the end of a trial, or at least after one side has been fully heard, or summary judgment, which happens before trial and is much more common. As I know, you're a fellow civil procedure professor. I know you know that. So at these pre-judgment moments, the court isn't supposed to terminate the case, even when a defendant, usually in this kind of case, moves for judgment, unless it concludes that no reasonable juror could find for the plaintiff on the issue at hand. So the body of law that's been built up around this notion of what a reasonable juror could and couldn't do holds that judges are supposed to be drawing all reasonable inferences on contested matters in favor of the non-moving party when these motions are brought up. And in my hypotheticals, we're mostly talking about plaintiffs who are the non-moving parties. They're responding to defendants' motions for judgment. So the question is, what constitutes drawing all reasonable inferences in favor of the plaintiff with respect to statistical evidence? And here is where I think that the approach that I'm proposing, and I should say, by the way, that the approach I'm proposing it has also been discussed in a paper that I've co-authored with, a more technical paper I've co-authored with Bruce Kobayashi at the George Mason University Scalia Law School. So anybody who's interested in the math can go look at that paper. I'd be happy to provide links. So where the approach really shines is it provides a way to think about what it means to be the most favorable set of inferences, to draw the most favorable set of inferences for the plaintiff. And that involves this plaintiff's most favorable juror concept. And simply put, the plaintiff's most favorable juror is the one who would walk into court with beliefs that tend to line up in a certain way. And I know we're a little bit low on time, so I'm not going to go into great detail. People can read the paper. But with beliefs that are especially favorable to the plaintiff, so that when the data that are observed in a study like the Lipitor one we've talked about, when those data are introduced at trial, such a juror would give the maximum benefit of the doubt, essentially, to the plaintiff having seen those data. And that notion of the plaintiff's most favorable juror turns out to solve the primary problem with the use of Bayesian methods from a conceptual standpoint. We haven't actually addressed this yet today, but that primary problem is that Bayesian analysis requires the specification of what are called prior beliefs. And in this context, they essentially have to be subjective beliefs, meaning they're not based on evidence that everybody has seen. It's just, some jurors walk into the courtroom being more favorably predisposed to plaintiffs, others more favorably predisposed to defendants, et cetera. The thing that holds Bayesian analysis back, even though I think basically everybody agrees it's the right way to do things if you knew the answer to this thing, the thing that holds Bayesian analysis back is the difficulty of figuring out how to specify these prior beliefs, the pre-evidence beliefs, in a way that isn't completely, subjective and essentially, in our context, lawless. Now, the most favorable juror idea says, hey, listen, if what we're directing our attention at is not who should win on the merits, because it's a pretrial motion after all, but rather, could any juror who's not crazy find for the plaintiff? Well, my argument is that actually gives us a lot of information about the kinds of prior beliefs that jurors might actually have. And it turns out, the argument goes, it actually gives us enough information to implement Bayesian reasoning at these very important pretrial milestone moments.
Right. And one thing that was really kind of helpful for me in conceptualizing this, so you really point out that like in most evidentiary contexts like this, sort of the Bayesian tools are really more like heuristics for thinking about or evaluating in a holistic sense. Like,
what's my prior belief about the probability that the defendant took due care in shoveling the walk, right?
Yeah.
Who knows what that means, right?
Yeah, but in this case, it's like we actually literally have exactly the data that you need to answer the question in a scientific way.
That's right, and I hesitate a little bit to use the word scientific because I think social
fair, yeah,
overclaim sometimes. but fine, fair enough. They are social scientists by our own designation, and all this travels under the reference manual for scientific evidence and so on. So fair enough. I would say it allows us to systematize the analysis, at least in these areas that involve quantitative evidence. And there's a section of the paper that engages at least one particular philosophical critique of that approach, and one that's sort of more about doctrinal law considerations and practical law considerations than about philosophical critiques. And my argument is, look, even if you folks are completely right in general, we don't even really need to engage the criticisms that you raise about the Bayesian model of evidence, the Bayesian theoretical model of evidence law writ large, because the objects we're interested in here really are quantifiable in probabilistic terms. I mean, that is the whole point. We're already using probabilistic analysis to answer these questions. We're just doing it, I argue, in a less good way than we could. So why not do it?
Yeah. So there was one thing that I was a little confused about, and I'm sure it's in the paper, or maybe it's in the paper and I totally missed it or didn't understand it. But like, what happens in this context if there are multiple conflicting studies introduced by different parties? Like, can you combine them together or parse them somehow and still come up with like the quote unquote right answer about what should happen? Or what do you do? What should a court do in that context?
That's a great question. So I do address that question to some extent, but it's easy to miss it because it's sort of in the middle of a whole. Those are trees in the middle of a much larger forest. So the first point I would say is that Federal Rule of Evidence 702B says that the testimony in question by an expert has to be based on sufficient evidence, sufficient information, sufficient facts and data, I think is the phrase. I don't have the rule right in front of me. There's a note, an advisory committee note to the rule that says by sufficient, what we mean is quantitative, not qualitative. So we're not saying legal sufficiency in the judgment as a matter of law, Federal Rule of Civil Procedure, Rule 50 sense, but rather what we literally mean, like you have to have paid attention to enough of the data that are out there. So think about an expert who walks into court and testifies about only half of the studies that have been done in an area. And you'd be stunned to know that if somebody did that, they might choose only the half that tended to favor their side, right? So I think it would be an entirely reasonable thing for for the judge, in response to a motion to exclude that testimony, to say, absolutely, that testimony is based on not enough evidence, and you have to take it all into account. Okay, so having said that, how do I say, and this is what I take to be the main thrust of your question, how do I say one should take multiple studies or multiple estimates into account? There's an appendix to the paper that handles the math of this, but the short answer to it is, what I say is that the expert should take the estimates from all those different studies and essentially average them, and then apply the rest of the machinery that I propose in this paper to the averaged estimate. Now, it's a little bit more involved than that, because it's probably the case that the best way to construct this averaged estimate would involve weighting with weights in a way that are constructed in a way that depends on the variance of each of the estimators and so on. So I'm going to leave out those details, but I'm just going to say that it's possible to construct an average that would be a reasonable summation of all the information, and then everything I'm saying should be applied to that average as if it were just one study. You can think of the expert who does such a thing as kind of creating their own meta study, and then we're just applying all the same logic to the meta study.
Oh, cool. Okay, that totally makes sense. Okay. So Jonah, in closing, right? I am 100% sold by your argument that based on what we say courts are supposed to be doing in the circumstances you describe, that you're right, that this is how they should be dealing with this kind of evidence based on that standard. So I'm wondering your thoughts on, like, in a kind of bigger picture sense or in a normative sense, what does that tell us about how courts should be thinking about evidence, or this kind of evidence, or maybe even any kind of evidence in that context? I mean, does it tell us that, yes, they should make this choice, or does it tell us, well, we should think about the nature of the choice that's being made and why we're making it in that way, and kind of think about what we're trying to accomplish under the circumstances?
Well, you asked the hardest question. I think that so if I put on my cynical economist hat, what I know a lot of people would say to me is, come on, these folks don't know how to think about these complex issues. In a lot of cases, the effects of choosing one standard or another are really hard to determine anyway, because they're going to affect how many cases are brought and which cases are brought, and all of those things go into figuring out what the right standard is. And why do you want to go and upset the apple cart? We have a kind of tacit understanding that even if this isn't what we're doing now isn't quite right, at least it's standard driven. And I've heard all of these points when I presented the paper at various workshops and talked to folks about them. I think there's something compelling about some of those points. But at the end of the day, I guess I'm enough of a legal scholar, and I take the law seriously enough that I think if we say we're doing the preponderance standard and we say that's the standard to which parties should be held, I have a really hard time with the idea that we should apply a standard that's just radically different from that in practice. And it's led, I think, to a lot of confusion in the courts, and judges saying a lot of things that are hard to feel good about. And so then the question becomes, well, okay, who's going to fix it? I have a discussion in the paper about the circumstances under which the substantive standard of evidence could be adjusted by courts, federal courts at least, operating through their common law powers, and it's a wider set of places than you might think. So, for instance, I think that there would be nothing wrong with the Supreme Court and failing that with courts of appeals in the meantime announcing standards for securities litigation, standards of evidence that are different from the preponderance standard, which is de facto what happened, for example, in the Halliburton case on its most recent trip, and its on remand after its most recent trip to the Supreme Court. I think if courts were honest about what they're doing and why, that would be okay with me. Personally, I think particularly in specialized areas like securities, I actually think the better thing would be to have folks who have the technical training to understand what they're doing and also are potentially responsible to democratic or at least, if not directly to democratic considerations, to those who are responsive to them, to be making these kinds of decisions and making them in a principled way that's transparently described. So you're probably at this point either wildly confused about what I'm saying or you know exactly what I'm saying, which is that we should have agencies be doing this, agencies with experts, who are trained in the methodology stuff and are able to figure out what are the effects of different standards, or at least estimate and predict them. And then we ought to have the responsible folks within the agencies take the technical advice from the experts that I just described and figure out what they think is the best standard, and they ought to promulgate regs that say that. I say that in the absence of any real confidence that Congress could be expected to get any of these things right on an area by area basis. I'm pretty unimpressed with Congress's technical expertise on these kinds of issues, or its capacity to deploy what it does have, as a result of the state of our politics. But I think agencies could possibly do a pretty good job at it. And I think if I were choosing, that's what I would choose. Probably second place would be, some sort of advisory committee through the Rules Enabling Act process. That would not work because it's substantive law. But if the courts were to try and get some sort of expert advice and then make overtly substantive law determinations on that basis, on the basis of those kinds of recommendations, that strikes me as an interesting idea. But really, then that's just courts operating like agencies, and there's a million reasons why folks might be bothered by that. So I personally would choose the agencies as the locus of those decisions.
Awesome. Well, Jonah, thank you so much. It's been really a pleasure having you on the program. And I'm just so pleased we were able to address so many of the rich, complex, and important points you make in this paper.
Well, thanks so much, Brian. It's been a pleasure to talk to you. And you asked lots of great questions and plenty of the hard ones. So this was really good, a really good workout for me. And I really appreciate the opportunity to talk about my work with you.
Hello, this is Beverly Garland. The Federal Trade Commission asks you to look beyond the smiling faces and super promises because the FTC knows that some advertising can be misleading and deceptive. So don't believe everything you see or hear. Beware of extravagant promises and unsupported claims. Check it out before you buy. Shop wisely. You'll save money.
This message is brought to you by the Federal Trade Commission, Washington, D.C.